Okay, let's unpack this. Today, we're diving into a really crucial area that touches many of our lives, especially if you own a dog, are thinking about getting one, or, simply care about public safety in your community.
Mhm.
We're talking about canine law, specifically Georgia's Responsible Dog Owner Act.
Right.
And this legislation, it goes far beyond just dog bites.
Mhm.
It's really a comprehensive framework designed to promote accountability and safety.
Yeah, quite detailed.
We've gone deep into the full text of this law, and our mission for this deep dive is to kind of extract the most important insights, helping you quickly understand what it truly means to be a responsible dog owner in Georgia and, the significant implications of this often overlooked area of law.
And what's truly insightful here, I think, is the level of detail embedded in this act.
Yeah.
Defines not just broad responsibilities, but very specific classifications and processes.
Right.
So this deep dive should offer you a clear shortcut to understanding the nuances of how dogs are regulated and, frankly, why certain actions lead to pretty profound consequences for owners.
So to begin, what's the core intent here? What's the big picture behind Georgia's Responsible Dog Owner Act? What problem is it trying to solve?
Well, fundamentally, this chapter sets state minimum standards for dog control and regulation, and it establishes state crimes for violations.
Minimum standards, okay.
But here's a crucial point. Local governments are not prevented from adopting and enforcing their own ordinances that are even more restrictive than these state minimums.
Oh, okay.
So you always need to check your local county or city rules, too. They could be tougher.
That's a vital detail. So local rules can indeed go above and beyond. Beyond just incidents involving people, what kind of general civil liability does this law establish for dog owners?
Well, the law makes it pretty clear that the owner or, the custodian of a dog is civilly liable for injury, death, or damage directly or indirectly caused by their dog. And this applies to any livestock, poultry, or pet animal while the dog is off their property.
Okay, so other animals too.
Yes. And they're also liable for any damage the dog causes to public or private property. This liability extends to what are called consequential damages.
So it's not just about attacks on people, but harm to other animals and property too. And the law clarifies this is cumulative, right? Meaning it doesn't limit other legal remedies.
Exactly. What that means for you, the owner, is that even if this specific act doesn't cover something, you could still face a separate lawsuit under, say, general negligence laws. It's like an added layer of protection for the public.
Got it. Now, this is where the rubber meets the road, I think. The law creates these two distinct categories, dangerous and vicious.
And they're very distinct.
Understanding these definitions seems absolutely critical because they trigger completely different sets of rules and consequences. Let's start by dissecting dangerous dog. What does the law consider truly dangerous?
Okay, so a dangerous dog is defined by very specific criteria. First, it causes a substantial puncture of a person's skin by teeth without causing a serious injury.
Substantial puncture.
Right. Think a significant bite that breaks the skin but isn't, life-threatening or severely maiming. A mere nip, scratch, or abrasion is not enough to classify it.
Okay.
Second, it aggressively attacks in a way that makes a person reasonably believe there is an imminent threat of serious injury, even if no actual injury occurs.
So even the threat can count.
Yes. But importantly, actions like just barking, growling, or showing teeth alone aren't enough. There needs to be a credible threat of attack, something more.
Right.
And third, while off the owner's property, it kills a pet animal.
Kills another pet. Wow.
Yeah. However, this third point doesn't apply if the dog is actively working or training as a hunting dog, herding dog, or predator control dog. There's an exception for working dogs.
Okay, so the law clearly creates this kind of graduated system, distinguishing between potential threat and actual harm. The key insight here for you listening is how Georgia's law differentiates dangerous from vicious, because this distinction dramatically impacts an owner's responsibilities.
Absolutely.
Let's dig into vicious dog next.
But-
What's the defining line that elevates a dog to this highest classification?
Okay, so a vicious dog is defined much more simply. It's a dog that inflicts serious injury on a person
Inflicts serious injury.
or causes serious injury to a person resulting from their reasonable attempts to escape from the dog's attack.
So the actual harm is the trigger.
Right. What's insightful here is that dangerous can be triggered by aggressive behavior that merely threatens serious injury, even without a bite. That's a proactive measure. Vicious, on the other hand, deals with actual serious harm. It raises the bar significantly.
And serious injury sounds like a very specific legal term here. What does the law mean by that in practical terms?
It's extremely precise, um, designed to leave very little room for doubt. Think of it this way. If it's life-threatening, requires major medical intervention like surgery or hospitalization, or causes long-term damage or disfigurement, it's likely serious injury.
Okay.
The law specifically lists things like any physical injury that creates a substantial risk of death, results in death, broken or dislocated bones, lacerations requiring multiple sutures, or disfiguring avulsions.
Convulsions where tissue is torn away.
Exactly. It also includes injuries requiring plastic surgery or admission to a hospital, or those resulting in protracted impairment of health, including, say, transmission of an infection or contagious disease, or impairment of the function of any bodily organ. It's a high bar.
Definitely. That level of detail really highlights the severity attached to these classifications. Are there any circumstances where a dog won't be classified as dangerous or vicious even if one of these events occurs?
Yes, the law outlines some important exceptions. A dog won't be classified for actions occurring while it's being used by a law enforcement or military officer carrying out official duties. That makes sense.
Right, service animals.
Also, a dog won't be classified if the person injured was, at the time, committing a trespass, abusing the dog, or committing or attempting to commit certain other crimes under the relevant Chapter 5 of Title 16.
So provocation or illegal activity by the injured person matters.
It can, yes. If someone is on your property illegally or actively provoking the dog, the classification might not apply.
So we've clearly defined these classifications, but, understanding the definitions is just the first step. The real impact comes from how these classifications are actually applied in real life. How does a dog go from an incident to being officially classified?
Right, the process. It begins when a dog control officer receives a report about a dog believed to be subject to classification. The officer then conducts a thorough investigation to determine if the dog meets the criteria we just discussed.
Okay, investigation first. Once the officer has gathered the facts and made their initial determination, what's the next step for the owner? What happens then?
Within 72 hours of making that determination, the dog control officer must mail a dated notice to the dog's owner.
72 hours, okay.
This notice summarizes the officer's finding and, crucially, informs the owner of their right to request a hearing. This hearing can be with an authority, think an animal control board or local board of health, or, if no such body exists locally, the probate court.
And how long does the owner have to ask for that hearing?
They have a narrow window, just 7 days from the date on the notice, to request this hearing.
7 days. That's a really tight turnaround. What happens if the owner doesn't request a hearing within that time? Do they just accept the classification?
Pretty much. If a hearing isn't requested within that allotted time, the dog control officer's determination becomes effective for all purposes under the law. There's no further challenge at that stage. And there's another point. If an owner cannot even be located within 10 days of the determination, the dog may be released to an animal shelter or potentially humanely euthanized by the dog control officer's decision.
So inaction has serious consequences.
It really underscores the urgency for owners to respond promptly to that notice.
Okay, but what if a hearing is requested? What does that process look like for the owner?
If requested, the hearing must be scheduled within 30 days of the request, though it can be continued for good cause shown.
Right.
At least 10 days before the hearing, the owner receives written notice of the date, time, and place. At the hearing itself, the owner gets their chance. They can testify, present evidence, call witnesses perhaps, and the authority or the probate court will receive other necessary evidence from the dog control officer and anyone else involved.
And then the decision.
Within 10 days after the hearing, the owner receives written notice of the final determination from the hearing body.
So there's a clear process for challenging the classification, ensuring some due process for the owner, and I assume there's a path for judicial review after that too, appealing to a higher court.
Yes, the law typically allows for appeals of these administrative or probate court decisions to the Superior Court following standard legal procedures.
Okay. So what does this all mean for you, the owner? If your dog is classified after all this, what are the immediate practical changes and requirements you'd suddenly face?
Well, the big one is it becomes unlawful to even possess a classified dog without obtaining a specific certificate of registration issued according to this law.
A certificate of registration.
Yes, and these certificates are non-transferable.
Mhm.
You can't just give the dog and certificate to someone else. They're only issued to individuals 18 years or older. And importantly, only one certificate is issued per domicile, per household, regardless of how many qualified adults live there.
Only one classified dog per home. That's strict.
It is. The law clearly places a very high bar for owners of classified dogs. I think the intent is pretty clear, ensuring these dogs are meticulously managed.
Okay, so what are the specific requirements then for registering a dangerous dog? The lower classification first.
For a dangerous dog, the owner has two main obligations. First, maintain a proper enclosure designed to securely confine the dog on their property.
Secure enclosure? What does that mean exactly?
It means the dog must be kept indoors or in a securely locked and enclosed pen, fence, or structure that absolutely prevents the dog from leaving the property on its own. It needs to be escape-proof.
Right.
Second, clearly visible warning signs must be posted at all entrances to the premises where the dog resides, notifying people, visitors, delivery drivers, emergency responders of the presence of a dangerous dog.
Okay. Enclosure and signs for dangerous. Now, what about a vicious dog? Are the requirements even more stringent, given it's the higher classification?
Oh yes, definitely more rigorous for a vicious dog. They must meet those same secure enclosure and warning sign requirements. Plus, a couple of significant additions. The dog needs to have a microchip with an identification number injected between its shoulder blades.
Microchip. Standard practice now mostly, but mandatory here.
Mandatory, yes. And, crucially, the owner must maintain and provide proof of general or specific liability insurance
Ah, the insurance. How much?
in the amount of at least $50,000 issued by an authorized insurer covering bodily injury or property damage caused by the dog.
$50,000 in liability insurance. That's a significant financial commitment.
It really is, and it demonstrates the increased level of perceived risk and responsibility associated with a vicious classification.
That insurance requirement really underscores the severity. Are there any reasons someone wouldn't be issued a certificate of registration, even if they meet those physical requirements like the fence and signs, and the financial one like insurance?
Absolutely. The law has several disqualifiers. A certificate will not be issued to anyone convicted of two or more violations of this article itself. The law aims to prevent repeat offenders under this specific act from owning classified dogs.
Okay, so prior violations matter.
Yes. Furthermore, no person is allowed to own more than one vicious dog, period.
One vicious dog limit per person.
And, very importantly, a certificate for a vicious dog will not be issued to anyone convicted of certain serious crimes.
Like what?
Things like a serious violent felony, as defined in Georgia law, the crime of dogfighting, aggravated cruelty to animals, or certain felonies involving controlled substances or marijuana trafficking.
So a serious criminal record can prevent ownership.
Yes, from the time of conviction until 2 years after completing their sentence, including any probation or parole. And this restriction also applies to anyone residing with such a person.
Wow, so it affects the whole household potentially.
Correct. The law definitely ties the ability to own a vicious dog to a person's, and even their household's, criminal record in significant ways.
Given all these strict requirements, is this registration a one-time thing, or is it an ongoing responsibility?
No, definitely not one time. Certificates of registration must be renewed annually, every year. And at the time of renewal for a vicious dog, a dog control officer actually verifies continued compliance. They check the enclosure, the insurance, everything, ensuring the owner is still meeting all the safety measures.
And if you don't renew,
Failure to renew within 10 days of the renewal date is itself a violation of the article. So you have to stay on top of it.
beyond the initial registration and the annual renewal, what are the ongoing duties and prohibitions for owners of classified dogs, like day-to-day stuff?
There are several key ongoing duties. Owners must notify the dog control officer within 24 hours if their classified dog gets loose or if it has attacked a human.
24-hour notice for incidents.
Yes, and also if the dog has died or been euthanized. This ensures authorities always have an up-to-date status on the dog.
Makes sense.
Also, vicious dogs generally cannot be transferred, sold, or donated to another person. The only typical exception is transferring the dog specifically for euthanasia at a governmental facility or a veterinarian's office.
So rehoming a vicious dog is basically prohibited.
Generally, yes. And then there are rules about moving. If an owner moves within Georgia, they must register the classified dog in the new jurisdiction within 10 days and also notify the old jurisdiction that they've moved.
Quick turnaround for moving, too.
Very. And if someone moves into Georgia from another state with a dog that would meet the classification criteria here, they have 30 days to register the dog under Georgia's law.
So imagine you're a new resident moving to Georgia with a dog previously classified elsewhere, or one that clearly fits the definition.
Right. You have a very limited time, 30 days, to get compliant with all these Georgia requirements, the enclosure, the insurance, if vicious, the registration, or you're immediately violating the law.
Okay, that covers responsibilities on the owner's property and administrative duties. Now let's talk about public safety more directly. What are the rules for taking a classified dog off the owner's property?
This is critical. For a dangerous dog, the lower classification, it's unlawful for it to be off the owner's property unless one of a few conditions is met.
Which are?
Either the dog must be restrained by a leash not exceeding 6 feet in length and be under the immediate physical control of a person capable of preventing it from engaging any other human or animal.
6-foot leash, capable handler.
Exactly. Or, alternatively, it could be in a closed and locked cage or crate. Or, the exception again, if it's actively working or training as a hunting, herding, or predator-control dog in an approved manner.
Okay, that's for dangerous dogs. What about for a vicious dog, the highest classification? What are the restrictions for them off property?
For a vicious dog, the rules are even tighter, as you'd expect. It's unlawful for it to be outside its secure enclosure, even while on the owner's property, or outside a securely locked pen or structure.
Even on their own property?
Yes, outside that primary secure enclosure, unless it meets strict criteria. It must be muzzled, AND, restrained by a leash not exceeding 6 feet AD, under the immediate physical control of a person capable of preventing it from engaging with others.
Muzzle, leash, and control. All three.
All three, just to be outside the main enclosure, even in its own yard. And off property, the same applies. Muzzle, 6-foot leash, capable handler. Or, like a dangerous dog, it could be in a closed and locked cage or crate.
And there is something about minors.
Yes. Crucially, a vicious dog cannot be left unattended with minors at any time. Full stop.
That's a very significant restriction, requiring a muzzle just to be in the yard, strict control off property, and absolutely no unattended time with minors. What are the penalties if these rules for off-property conduct are violated, particularly for the vicious dog rules?
A person who violates those specific vicious dog off-property rules, the muzzle, loose control, minor supervision, is guilty of a misdemeanor of a high and aggravated nature.
High and aggravated misdemeanor, what does that typically mean?
It generally means a more severe penalty than a simple misdemeanor. Often involves potentially higher fines, maybe longer potential jail sentences up to 12 months, and less likelihood of diversion programs compared to a standard misdemeanor. It signals the seriousness of the violation. Now, if we connect this to the bigger picture, the penalties can become much, much more severe, especially for repeat offenses involving actual harm.
Oh, so?
An owner who has a previous conviction for any violation of this article, maybe they failed to register or violated the leash law once before, if their classified dog then causes serious injury to a human under circumstances constituting another violation.
So a prior offense plus a new serious injury incident.
Then that owner is guilty of a felony.
A felony.
Yes. And upon conviction for that felony, they face imprisonment for 1 to 10 years, a fine of $5,000 to $10,000, or potentially both.
1 to 10 years in prison, that's substantial.
It is. And in addition to the owner's penalty, the law states the classified dog involved shall be euthanized at the owner's cost.
So in that specific scenario, prior violation, new serious injury euthanasia is mandatory.
That's what the text says. It uses the word shall, which in legal terms typically means it's required, not discretionary. This is a critical point where the law commands euthanasia.
That's a very sobering consequence, with severe implications for both the owner and the dog. What about confiscation? When can an officer actually take possession of a classified dog?
The law is quite direct here, too. A dangerous or vicious dog shall be immediately confiscated by any dog control officer or law enforcement officer if there's any violation of the article occurring.
Any violation triggers immediate confiscation.
That appears to be the rule. If the dog is off leash, if the registration lapsed, if there's an incident, confiscation can happen immediately. And refusal to surrender the dog during such a confiscation is also a violation of the article.
What happens after confiscation? Can the owner get the dog back?
The owner can recover the dog, but only by paying all reasonable confiscation and housing costs and providing proof of full compliance with the law, fixing whatever the violation was, getting insurance current, etc., unless, of course, the confiscation itself is determined to have been an error.
And if they don't comply quickly?
If the owner hasn't complied within 14 days of the confiscation, the dog is then released to an animal shelter or humanely euthanized. And the owner may still be required to pay the housing and euthanasia costs.
So again, the clock starts ticking the moment a violation leads to confiscation. 14 days to get fully compliant.
Exactly. It puts the onus squarely on the owner to rectify the situation fast.
This raises another important question. We talked about mandatory euthanasia after a second serious injury by a classified dog owned by someone with a prior conviction. But are there other circumstances where euthanasia can be ordered under this law, even if it's not automatically mandatory?
Yes, there's another provision. A judge of any superior court can order the euthanasia of a dog if the court finds, after notice and opportunity for hearing, two things. First, that the dog has seriously injured a human or presents a danger to humans not suitable for control under this article's provisions.
Okay, serious injury or uncontrollable danger.
And second, either the owner or custodian has been convicted of some state criminal law related to the dog's actions, or a local governmental authority, like the county or city, has specifically filed a civil action in court requesting euthanasia.
So in those cases, a judge can order euthanasia, meaning it's discretionary based on the findings.
Correct. It's not automatic like the other scenario, but it provides a legal path for euthanasia based on a judicial finding of severe danger or harm, linked either to a criminal conviction or a specific civil request by the government.
But just to reiterate, is there any other scenario where euthanasia is absolutely mandatory, where the law says it shall happen, no judge's discretion?
Yes, there's one more absolute mandate. A dog that is found, again, after notice and opportunity for hearing, to have caused a serious injury to a human on more than one occasion.
Regardless of the owner's prior record.
Correct. If the dog itself is found to have inflicted serious injury twice, it shall be euthanized.
2 strikes and you're out. For the dog in that case.
Essentially, yes. But there's a date qualifier here, too. It's important to note that injuries occurring before July 1st, 2012 do not count for this specific "to serious injuries" subsection. This clause applies only to incidents from that date forward.
That's a critical date, again illustrating how the law has evolved over time. Okay, one final point, which seems important for understanding the scope and limitations of this law. Sovereign immunity. What does that mean in this context, maybe for someone who might be injured?
Right. Sovereign immunity is a legal doctrine that generally protects government entities from lawsuits. In this specific law, it provides a significant limitation on liability for governmental bodies. The text states that, under no circumstances shall a local government or any employee or official be held liable for any damages to any person who suffers an injury inflicted by a dog as a result of a failure to enforce the provisions of this article.
Okay, break that down. What does it mean practically?
In plain terms, if a city animal control officer or the county government somehow fails to enforce this law, maybe they don't classify a dog they should have, or they don't confiscate a dog when required, and then you get injured by that dog as a result of that failure.
You can't sue them for it.
Correct. You cannot sue the city, the county, or the individual officer for damages resulting from their failure to enforce this specific act. It protects the government from liability in that specific scenario.
That's a really important limitation to understand. Okay, last question on the law itself. What if a dog was classified under an older version of Georgia law before this current act took full effect around 2012? Does that classification just disappear, or does it carry over?
No, it carries over. The law specifically addressed that transition. Any dog classified as potentially dangerous under the old law before July 1st, 2012, automatically became classified as a dangerous dog under this updated article as of that date.
Okay, potentially dangerous became dangerous.
Right. And any dog that had been classified under the old system as dangerous or vicious before July 1st, 2012, automatically became classified as a vicious dog under the new act.
So the old dangerous became the new stricter vicious.
Exactly. And owners of all those previously classified dogs were given a deadline they had until January 1st, 2013 to come into full compliance with all the current provisions for their new classification, like the insurance for vicious dogs, the specific enclosure rules, etc.
That really demonstrates, for anyone listening, this isn't just a static law. It evolved, the classification shifted, generally becoming more stringent, likely reflecting a legislative intent over time to increase public safety measures related to dogs perceived as higher risk.
Precisely. It wasn't just a rewrite. It was an upgrade of the requirements.
So wrapping this up, what does all this mean for you? We've taken a really deep dive into Georgia's Responsible Dog Owner Act. We've unpacked its core intent, those crucial legal distinctions between dangerous and vicious dogs.
The definitions are key.
The detailed classification process from report to hearing, and the really extensive responsibilities placed on owners once a dog is classified. We've covered everything from securing your property, getting that liability insurance for vicious dogs, the strict leash and muzzle laws, and even the conditions that can lead to mandatory euthanasia.
And this framework, it clearly aims to strike a balance, right, between the individual rights of pet ownership and the need for robust public safety measures. Understanding these legal nuances is just essential, whether you're a current dog owner thinking about adopting or, frankly, just someone interacting with dogs out in your community.
Yeah.
It profoundly underscores the legal and ethical responsibility that comes with canine companionship. It really emphasizes that awareness is or should be a cornerstone of owning a dog in Georgia today.
So, for you, the learner, hopefully this deep dive equips you with the knowledge to understand the stakes involved and the specific obligations that come with dog ownership under this law. It's about knowing not just what the rules are, but really why they seem to be in place and the serious implications if they're not followed.
Right. And maybe something to think about, connecting this to the bigger picture. Considering all these layers of legal responsibility we've discussed, how might a community best foster both responsible pet ownership and public well-being, especially without resorting to something like breed-specific legislation, which this law notably avoids, focusing instead on behavior, purely based on what this law outlines? What additional proactive measures might this framework encourage beyond just reacting after an incident?
That's a great question. What proactive steps could complement this reactive framework? Something to think about as you go about your day. Thanks for joining us for this deep dive.